Hey, I'm Sarah, a senior lawyer at Legal Aid's Parramatta office. At university, I took lawyers, ethics, and justice at UNSW under Steve Mark. Today, I received two files for casework allocation. Both cases relate to an incident from February this year when Pete and Dustin were caught trespassing on a neighbor's property. Pete has been charged with entering a dwelling house, which is punishable by up to 10 years. Dustin has been charged with the same offense, however in a circumstance of aggravation, namely that he used corporeal violence on a resident. This is punishable by 14 years. The notes from Sam, the junior lawyer that represented the co-accused at first instance, indicate that Dustin and Pete have the same story. However, Sam also noted that he has a fishy feeling about their story.
I kicked a footy and it went in my neighbour's house, I swear. I was just going in to get it. I didn't know anyone was home and I wasn't going in to steal anything. We only ran out because our neighbour scared us, and Dusty just accidentally knocked him over.
Yeah, that's what happened.
So now, drawing on my ethical decision-making skills, I need to work out how to allocate the two files for casework. I've decided to follow the Queensland Law Society model to help me. So first I need to identify the specifics of the issue. I know that there are ethical issues that could arise in representing two co-accused, however, I don't know the extent of these obligations. Luckily for me, I can call senior attorney Margot Robbie for help and advice. I just hope she's not busy.
Basically, representing two co-accused is a big ethical wormhole. You get sucked in further and further until suddenly you're breaching solicitors' rules and a client has their hands around your neck. Let me tell you something. The Supreme Court said as much in the Crown against Fam, where McMurdo, my bro, was like, damn, trials are notoriously unpredictable. Unanticipated evidence or submissions can result in a conflict of duties owed to two co-defendants, with a risk of prejudice to one or all co-defendants. Essentially, because one defendant may be more culpable than another, they could exercise some real mask energy and manipulate those that are less dominant to give instructions to their detriment. Not hot guy shit, I know. Sarah, remember you have an obligation to act in your client's best interests per 4.1, not disclose confidential information per 9.1, and avoid conflicts between current clients per 11.1. The next step for Sarah is identifying her options as well as the interests at play. The first consideration is whether a lawyer from Legal Aid Parramatta could represent both Dustin and Pete. Though Dustin and Pete would prefer this option as they are comfortable in each other's presence and both live locally, Sarah is aware that subject to some exceptions, law practices are prohibited from acting for two or more clients where the potential for conflict could arise, per Rule 11.2. This is because there is a basic prescription against acting for two clients where there is a conflict of interest. A lawyer must act in the best interests of their individual client, as per Rule 4.1. Given Sam's fishy feeling about Dustin and Pete's story, it is clear that this option isn't appropriate. Sarah's next option is only granting one of the co-accused legal aid. This is contentious as there is a high prospect of trial going ahead. Sarah knows that neither Dustin and Pete can afford legal representation, meaning that if she didn't grant one of them legal aid, they would go unrepresented and would likely receive an unduly harsh outcome. As a community lawyer, Sarah has both a professional and a moral obligation to ensure access to justice. Denying an underprivileged person access to legal service would only further entrench their disadvantage. It also may act as a disadvantage to the court, as an unrepresented defendant may slow proceedings. Sarah knows that she needs to find a balance between her ethical obligations and the moral obligation to ensure access to justice. However, she rules this option out immediately. A third option involves referring either Dustin or Pete to a different legal aid office in Sydney, which would protect the confidentiality of any information provided by either client. On the flip side, finding alternative legal representation may cause additional stress and anxiety for the client, and oftentimes they proceed to trial with no legal representation. Owing to COVID-related staffing constraints, however, these offices are not accepting any referrals. Sarah is an adversarial advocate and wants to ensure that she exhausts all options before anyone who seeks her help goes unrepresented. Finally, Sarah considers whether she can allocate both clients to different solicitors at Legal Aid Parramatta. She knows that the solicitor's rules don't allow a single practice to act for two conflicted clients, subject to the exception in Rule 11.3, including its additional requirements in 11.4. The requirements of these rules are twofold. First, Sarah needs to gain both clients' informed consent for a different legal aid lawyer to act for the other co-accused. And second, she needs to set up an information barrier between the solicitors acting for each client. To gain informed consent, Sarah would need to explain the situation to Dustin and Pete in layman's terms, outlining the potential risks of one legal practice representing two co-accused, as well as the other options she has considered and ruled out. Sarah calls both Dustin and Pete independently and explains the scenario to them. Pete is eager for Sarah to represent both himself and Dustin, but Sarah is firm in explaining that this is impossible. In Sarah's mind, Pete's eagerness reinforces the comment about the suspiciousness of their stories. Irrespective of this, they both consent to being represented by lawyers in the Parramatta office. Next, Sarah needs to work out whether she can establish an effective information barrier as required by Rule 11.4. Information barriers refer to organisational arrangements which preclude the passing of information in the possession of one part of the business to other parts of the business, as established in Bulkier and KPMG. It is generally accepted that good informational barriers are established within institutions and not required ad hoc. Further, and as discussed in Bulkier and KPMG, though information barriers may be well adapted to deal with foreseeable or deliberate disclosure of information, they will not always counter inadvertent disclosure. Sarah is anxious as she knows that the information barriers within the criminal law team at Legal Aid Parramatta are infrequently used and highly informal. Like the other legal aid officers, her office is also facing staffing constraints, and the handful of lawyers in the office are all close-knit and give each other advice on their cases regularly. Sarah identifies one solution in making use of the existing information barrier between the civil and criminal teams at Parramatta. After consulting with a senior civil lawyer, Sarah confirms that she could provide a criminal lawyer with an office space in the civil wing to complete work on Dustin's case, as well as space for file storage. Though this is no solution to a risk of inadvertent disclosure of confidential information, including in a court environment, Sarah knows that the broader ethical dilemmas associated with denying one of the co-accused access to legal advice are persuasive. Accordingly, she makes the decision to take on Pete's case herself, allocate Dustin to Sam, and establish an information barrier using the existing civil and criminal law. Having made a decision, Sarah is annoyed that there isn't already a policy in place to guide lawyers through her same issue. Accordingly, Sarah develops a document laying out the dominant reasons for her decision, including 1. The significant potential for a conflict, including manipulation of Dustin by Pete if a single lawyer represented them. 2. The risk of grievous outcomes if either Dustin or Pete were unrepresented. And 3. The capacity of Legal Aid Parramatta to establish information barriers. Though Sarah's allocation anxieties are over, her crisis in casework is about to begin. Enter cognitive dissonance. Sarah has begun preparing for Pete's hearing, and after many meetings with Pete, building a relationship based on trust, he makes a significant disclosure.
Look, though I did kick the footy into that house, it might have been intentional. That old man just lives there alone, and I reckon he probably has a lot of stuff he doesn't need. I just wanted to have a look. It was just unlucky that Dusty happened to be walking by as I was going in. I didn't think he knew what was going on. Sure enough, though, the young lad was happy to earn his stripes by going along with the story. And with my record on the line, I'm bloody lucky I had someone else take the fall for pushing that old geezer over.
At this point, Sarah knows she has an obligation of client confidentiality to Pete, per Rule 9.1, but she can't help but feel terrible about the potential outcome for Dustin. At just 18 years old, aside from this charge, he doesn't have a criminal record. In this decision, the rest and breaky model suits Sarah's decision-making process the best. Can you recall what the 6 stages are? Did you think awareness, judgment, decision making, action, achievement, and review? Step 1 relates to Sarah's awareness of the issue, which involves identifying the ethical dimensions. Sarah knows that this is a point of tension between her legal duties and her own moral compass. Allowing Dustin to take the fall for an offence he did not commit is morally problematic. However, disclosing Pete's information is adverse to his best interests as her client. Wendell would describe this tension as role-differentiated morality. That is, the tension between the requirements in a legal capacity and with what others might expect ought to occur. Unfortunately, this type of circumstance is not new to lawyers such as Sarah. We can all remember the harrowing buried bodies case, where lawyers Armani and Belg were found to have known the location of the victims' bodies. While these attorneys received support from the legal community, they were put under fire in the court of public opinion. In the years following, Armani built up his practice, but Belg gave it up altogether, proving that maybe nice guys don't always finish last. While Sarah must maintain her legal duties to Pete, she is also under an obligation to communicate advice that assists him to make an informed choice about any action that has been taken, as per 7.1, and she might also discuss any alternative actions open to him, as per Rule 7.2. Now, step 2. All this is to say that Sarah must make a judgment about what morality requires of her, so as to lead her to a decision about what to do next.
I brought these issues to Pete in our last meeting and emphasized the impact that a criminal conviction would have on Dustin at only 18 years of age.
Yeah, nah, he's keen for the cred. And he don't seem coming forward to tell the world the truth. I don't want to go away again for the long haul, so there's no way I'm owning up, especially when he's just sitting back.
Now, I know for certain I cannot disclose Pete's full culpability, and I must make a final decision about whether to represent him or to withdraw from the case. Representing him may prove difficult, as I cannot suggest that another person committed the offense due to Solicitor's Rule 20.2.2, nor present a positive case inconsistent with his disclosure following Solicitor's Rule 20.2.8. I also know that not representing Pete has many ethical downsides, because if I don't help, Pete will likely be unrepresented. In addition to Pete, I have my own concerns to think about. What will happen to my reputation if I do represent Pete? What will happen if I don't represent him? Will I be able to move on professionally if Dustin receives a severe sentence for a crime he didn't commit?
Sarah weighs up all these factors in order to come to a decision about how to act, and she decides to represent Pete. At this point, she takes action by following through on her decision. She and Pete discussed how they will navigate the trial process and what evidence can and cannot be adduced. However, Sarah is careful not to overcoach Pete. By doing so, Sarah is highlighting a blended approach of the ethics of care and responsible lawyering conceptual frameworks presented by Parker and Evans. She has attempted to maintain her relationship with Pete and has continued to uphold her duty as an officer to the court and a trustee of the legal system. To implement their decision, Sarah goes to trial with Pete. Whilst representing him, she cannot help but wonder whether she has made the right decision. Though her deep reflection on a difficult moral issue can be applauded, there are competing arguments as to whether she made the right decision. Sarah's actions are reflective of the standard conception, as they align with the 3 principles of neutrality, partisanship, and non-accountability. This is evidenced in the fact that Sarah has established some moral detachment. She has focused on advocating for Pete's needs in her professional capacity as Pete's lawyer, and she does not hold moral responsibility for his actions. However, Sarah's choice of representing Pete anyway is not without controversy. As David Laban observes, an occasional lapse from zealous representation of a particularly dangerous and repulsive criminal defendant would not do much damage to criminal defense as a whole and might do a lot of good. It is obvious that Pete is a dangerous criminal. Let's hear what Dustin has to say for himself.
I'm so grateful because Sarah found me a paralegal officer, and she told me not to be a hooligan in the future. Now I also want to study law when I grow up, but I wonder if I'm still a fit and the proper person to be a lawyer.